Hi, my name is Attorney Roy Galloway. I'm the owner of the law office of Roy Galloway, LLC, and I want to talk about a common question that I receive from clients. And that question is, how do I defend against a drug trafficking case? And there's basically two ways that we typically defend against a drug case. First, I want to start off by explaining that we have certain constitutional rights. So one of the ways that we defend against a drug case is by trying to get suppression of the evidence. We do that by looking at the facts and circumstances of the case to determine if law enforcement made a procedural error. We have certain rights under the federal Constitution, the Fourth Amendment, that protects us from unreasonable searches and seizures, as well as the Pennsylvania Constitution that gives us greater protections than its federal counterpart. So oftentimes how we are successful in defending against drug cases is looking at the circumstances and determining whether or not law enforcement perhaps made an unjustified detention or stop of someone, not supported by reasonable suspicion that they were engaged in criminal activity, and perhaps then later found drugs on that person. If the initial seizure was illegal or not supported by the cop's observation of criminal activity, then we've been successful in the past at having drugs suppressed. That's a common way. Another way to have the drugs suppressed, it doesn't fully exonerate you all the way, but sometimes the other way that we do it is we claim that, the person possessed the drugs not with the intent to deliver the drugs, but with the intent to use it. There's a huge difference with respect to sentencing. It's an ungraded misdemeanor to possess the drugs for personal use. There's penalties up to a year versus possession with intent to deliver carries a maximum sentence of 15 years, and it's a felony. So sometimes where a party's rights have not been trampled upon by law enforcement, there's no search and seizure issue. We rely on proving that the client actually possessed the drugs, not with the intent to deliver, but with the intent for personal use. And we do that by looking at several circumstances. Perhaps the party was under the influence of the drug at the time that they were arrested and were tested and had drugs in their system. We look at the amount and quantity. So perhaps the person had a small quantity of drugs on their person, something that you're not going to sell. Maybe it's in one baggie versus a person that has 10 baggies. 10 baggies more indicia of I have an intent to deliver, but one bag with a small amount may be an indicator that the party is possessing the drugs with the intent to use it. Another indicator or factor we might look at in trying to prove that the person possessed the drugs for personal use would be if they had use paraphernalia with them, rolling papers, etc. That would show that that person intended to use the drugs for their own personal use. So if a person has a small quantity of cash, small quantity of drugs, they have paraphernalia consistent with use of the drugs, those are indicators that might convince a jury that the client actually possessed the drugs with an intent to use versus with the intent to deliver. If you're being charged with a drug offense, you need an aggressive and experienced attorney on your side, an attorney with a proven track record, an attorney who has gotten drug evidence suppressed on numerous occasions. Please do not hesitate to call the law offices of Roy Galloway at 717-737-3300. Thank you.